Hear ye, hear ye, hear ye. The United States Court of Appeals for the Fifth Circuit is now open according to law. God save the United States in this honorable court.
Good morning, Mr. Strawn, Ms. Pettit, and Mr. Woofter. I'm Judge Dennis, together with Judge Hicks and Judge Engelhardt. We will be your panel on this one case we have for argument today. The case being number 20-40337, consolidated with 20-40683. Parties are David Allen Haverkamp, also known as Bobby Lee Haverkamp, plaintiff appellant, versus Dr. Lynette Linthicum, Cynthia Jumper, F. Parker Hudson, Philip Kaiser. I guess that's all the parties. I think there's some others, but I won't read those out. So the argument today is allocated first 6 minutes to Mr. Strawn, 10 minutes to Lanora Pettit, and then 20 minutes to Mr. Woofter, and with 4 minutes on rebuttal to Ms. Pettit. So with not having made all that speech, I'll turn it over to the lawyers. First of all is Mr. Strawn. Go ahead, sir.
Thank you, Your Honor. May it please the court. I represent Philip Kaiser, MD, who is a doctor who's been sued as a member of the Correctional Managed Healthcare Committee, which I'll refer to today as just the committee. And I'm going to be arguing on behalf of the other similarly situated members of the committee. And Ms. Pettit will take the second half of the argument, and she's going to address issues that are more particular to Dr. Linthicum, who is a member of the committee, but also serves as the Director of Health Services for the Texas Department of Criminal Justice, or the TDCJ. The essence of this lawsuit is that the plaintiff has sued, claiming that it is a violation of the Equal Protection Clause to not receive a sex reassignment surgery, which is a surgery that is not provided to any prisoner regardless of gender. The committee members have been sued, and it is not contested that the committee members would be entitled to 11th Amendment immunity unless the Ex parte Young exception applies. And I know this court has had a number of opportunities over the last year or two to address Ex parte Young. And I believe that two of those cases are particularly instructive here as to how the district court erred in not dismissing those claims. And I'm going to address those in order. And the first is the fact that the committee itself lacks enforceability powers, and that should preclude an Ex parte Young claim. And the second is that the relief that is sought from the committee is asking this committee to take an affirmative discretionary act, and that is simply something that Ex parte Young does not allow a district court to order. So looking at the first issue, you have to look at what the committee actually is. The committee is made up of 10 physicians from around the state of Texas who are appointed to specify to the TDCJ the types and general level of care. That's in the Government Code 501-146. And contrary to what appellees have asserted, the committee is not statutorily tasked with resolving disputes between the TDCJ and physicians. At best, the committee may, and that's in the statute under 501-148, it may address any type of disputes, but there's no allegation in this case that the committee did address it or was asked to, or might even be asked to do so. But what's more instructive on this point is if you look at 501.146C, where it specifies that the committee is to provide expertise to the TDCJ in developing policies and procedures for implementation of the plan. And I think that's very important in this situation because implementation of the plan is the way in which the plan is enforced. And the TDCJ is the entity that implements the plan and enforces the plan, not the committee. The committee simply has no power to order the TCDJ to do anything, to adopt these policies, and it certainly doesn't have the power to order the TDCJ to pay for the surgery. It does not have the power to order a physician to provide this surgery, nor does it have the power to block the surgery, and it certainly, the committee does not have the power to order the TCDJ to provide the female commissary items, which is one of the elements of the plaintiff's claim. So if you look at this court decided in the Abbott case, citing the City of Austin case, and the quote is, if the official sued is not statutorily tasked with enforcing the challenge law, then the requisite connection is absent and our Young analysis ends. And I would submit to you that that's the proper decision in this case, is that since the committee is not statutorily tasked with enforcing this, they are not proper ex parte Young defendants. And the second aspect is really what is requested of the committee, which is a change in the policy. And that is really a request for the court to order a committee to take an affirmative step, an affirmative discretionary action to change a policy. I think, as the court stated in Richardson, and the court noted that it's an open question whether ex parte Young allows affirmative injunctions at all, but it's certainly, at a very minimum, a court may not control an officer in the exercise of his discretion. And that's quoting ex parte Young itself in the Richardson case. So here, if you really look what the plaintiff is requesting the district court to do, it's to order 10 doctors to research, to meet, to evaluate, and then decide not whether this controversial surgery is the standard of care, but the fact that it is the standard of care. And that's what's being requested in this case. And deciding the standard of care, ordering a committee to do something such as this, is the essence of a discretionary act. In other words, this is something that all of these committee members would have to get together and decide. And the court here is asked to order that. And that is simply
Counsel,
something.
It's probably in your brief, but refresh my recollection about the provision of the name. As I understand it, at some point over the past few years while this case was pending, counsel provided a list of people who are proper defendants. So if you could explain that in relation to the point you're making now, that might help.
Sure. What happened, Judge, and this is at page 1702 of the record, there was a status conference held early on before any of these the committee members were parties. So no one was there representing the committee members. And an attorney representing a different defendant was asked in the course of this discussion about what were the plaintiff's claims. And there was a lengthy discussion with the judge trying to figure out what exactly the plaintiff was asking for. And the answer was ventured as a guess within a status conference that if the plaintiff is seeking a change in the policy, then the members of the committee who write the policy would be the proper defendants. And that's factually accurate because they do write the policy, and they are the ones that they meet every, 4 times a year, I believe, and they do evaluate policies year after year. But that is very different from saying that those members of the committee, one, waive their 11th Amendment immunity, and two, whether the court actually has the power to order that type of discretionary act. In other words, it was a statement that was a guess during the process when they were trying to decide where is this case going. It was when the decision was awaiting the Gibson case, when there was the case was actually stayed, and the district court, or the magistrate judge in this case, said, let's at least try to get the proper parties here. Who can we do? And then if you look at the very last statement in the transcript, the district court says, well, let us know who those are. Let's get an amended complaint, and then we'll reconvene to decide who are the actual parties depending upon the actual allegations, and then we'll decide. And that's how that came about. And as soon as the stay was lifted, the defendants, including all the committee members, filed a motion to dismiss based upon the 11th Amendment immunity. I believe I'm out of time on that. So if you no further questions, I'll turn it over to Ms. Pettit.
Thank you, Your Honors, and may it please the court. Lanora Pettit on behalf of appellants other than Dr. Kaiser. At bottom, this is a dispute about who is the appropriate decision maker regarding whether an individual inmate gets a particular highly controversial medical procedure and under what circumstances. As my co-counsel just explained, the committee is not that relevant decision maker because they help to promulgate but do not enforce TDCJ medical policy. I'll now explain why Dr. Linthicum isn't that decision maker either, and give some additional information regarding why this court is not that decision maker, because the relief being sought is not available under Ex parte Young. Now, there's substantial overlap between these inquiries, and I think this also goes to Judge Engelhardt's question, because as this court recognized in Air Evac, the Ex parte Young analysis depends on the context of the specific complaint, including the relief sought, from whom, and on what basis. That analysis is never particularly easy, as this court recognized in one of a number of cases filed TDP against Hughes, but it's made particularly difficult in this instance because Haverkamp's pleadings on these crucial questions have been both internally inconsistent and eternally evolving. To Judge Engelhardt's question, the status conference that Mr. Strawn was just describing was in response to a pleading that Haverkamp filed suggesting that defendants had been, and I quote, blatantly lying when they suggested that Haverkamp had been denied sex reassignment surgery, one of the very forms of relief counsel seeks on this appeal. And I'm looking at page 555 of the record in 40683. So based on my reading of the record as a whole, the most consistently sought form of relief is that Haverkamp considers G51.11 to form a sort of contract between Haverkamp and the TDCJ, into which he's entitled to a particular surgery. For example, the clearest example of this is probably at ROA 1874. That claim runs straight into a Pinhurst problem. And so counsel on appeal pivots and asks first for an order requiring the surgery, and second, for an order preventing the defendants from stepping in and preventing that surgery. But those reliefs, particularly as they are sought against Dr. Linthicum, are either contradicted by or unsupported by the record. In particular, Haverkamp points to a single thing that supposedly connects Dr. Linthicum to this relief, and that is a 2012 version of G51.11, which says that the UTMB medical director is responsible for approving treatment plans for transgender inmates. However, Dr. Linthicum is not an employee of UTMB. She is TDCJ's medical director. And that is fatal to Haverkamp's claim against Linthicum because, as Mr. Strawn mentioned, in this court's decisions in City of Austin and in Ray Abbott, you stated that if a different defendant was specifically identified as the enforcer of a state policy, then the analysis ends, the plaintiff has sued the wrong defendant. Counsel seeks to avoid this conclusion by pointing to Dr. Linthicum's general job description as head of the TDCJ's medical program. However, this court has repeatedly held in the series of Hughes cases, as well as Richardson and in Ray Abbott, that this sort of allegation by job description is insufficient to satisfy Ex parte Young, because in a complicated legal regime, different rules can be enforced by different people. And that is precisely what happens in Chapter 501 of the Texas Government Code. Certain rules are enforced by Dr. Linthicum, others by UTMB. The others involve prison committees, the warden. There are lots of people. You need to identify a particular type of regulation that this particular defendant enforces, and plaintiff has not done that. So, to the contrary, plaintiff has, since this appeal has been filed, and I'm looking at docket 250, which was filed about 6 weeks ago, has actually asked to dismiss Dr. Linthicum because she has not become personally involved in Haverkamp's treatment decisions. The easiest way for this court to resolve this appeal is to reverse and remand with instructions to grant that motion. But even if you were to disagree with me on that point, the types of relief that are being sought here, which I count at least 5, they all run afoul of the limitations of Ex parte Young. The first one was one that I just mentioned, which is that it's an enforcement of a contract, which runs afoul of Pinhurst. The second is the one that Mr. Strawn mentioned, which is a change in policy, which runs afoul of Richardson. The other 3 are the ones that counsel seeks in 40683, which is an order preventing the defendants from stepping in the way of the surgery. But that is not supported by allegations in the actual complaint. Instead, the complaint is that the doctors have not identified and haven't ordered the surgery to happen. And so as a result, the defendant, as counsel recognized in the hearing that Judge Engelhardt mentioned a few minutes ago, the appropriate defendant there is the doctor, and the doctor is not a party to this case anymore. So that leaves two potential remedies, both of which solve the same problem as the change in policy, namely the adoption of a comprehensive treatment plan with a specific standard of care, which is effectively a request for a change in policy in different terms. And the second is to order the surgery itself. But that surgery is also a highly discretionary act involving multiple parties, some of whom are not parties to this lawsuit. In particular, assuming that Haverkamp is correct, that the WPATH guidelines are the guidelines that should be applied in the prison context, which is far from clear, as this court recognized in Gibson, following the First Circuit in Courtroom. There have to be at least 3 physicians who agree that this surgery is appropriate, none of which has happened here. So this court would be dictating to doctors to perform a type of surgery that WPATH itself recognizes is controversial, and some surgeons are simply not comfortable providing it. So that is a type of discretionary relief that this court does not offer. Neither is the other options that the plaintiff has requested. And turning briefly to the additional claims in the complaint, specifically female commissary items, as I see I have some additional time, this is not all, the provision of those is also both a discretionary question and something for which these are not the appropriate defendants. Starting with the discretionary question, we don't have the same complicating factors as to whether or not the doctors have ordered these items, because they have. However, the way to control and to provide security in a prison where it is a single-sex prison and these are female commissary items identifying the plaintiff as a potential subject of abuse is a highly complicated concept that is regulated by a number of different rules and a number of different committees that require deep thought, and that regulation is itself discretionary. But even if it weren't, the record makes clear, and I'm looking particularly at ROA 133 as well as ROA 72 and 89, the defendants here who are medical staff have done all they can to provide Haverkamp with these services. The problem appears to be at the prison level, specifically the warden or the people who stock the commissary itself, who are once again not defendants here. Because the people who could provide this relief are not before the court, and they would not be bound by any order this court were to issue, Ex parte Young relief is not appropriate. Haverkamp lacks standing, and this case should be dismissed. Thank you.
Thank you. Mr. Woofter?
Good afternoon, Your Honors. Daniel Woofter, appearing on behalf of the plaintiff appellee in this case, Bobby Lee Haverkamp. If it sounds like my friend on the other side is raising a number of factual reasons why these are not the proper defendants, either because of their roles as committee members or because of Dr. Linthicum's role and her powers as the Director of Health Services, it's because that's exactly what the state is doing. And for the reasons given by the district court, that is an improper issue to resolve at this motion to dismiss stage. And as the district court found, Haverkamp, my client, actually plausibly did allege that both the committee members and Dr. Linthicum, in her role as both a committee member and the Director of Health Services for DDCJ, would be proper defendants under the Ex parte Young analysis. Most importantly, for the reasons of this appeal, is that the state raises a number of arguments for why these are not the proper defendants, but it doesn't say they don't say who is. In one passing reference in one of the opening briefs, the state seemed to suggest that it should be the treating physician. Of course, here, Haverkamp has alleged that her treating physician actually did prescribe her the surgery that she seeks. And that someone in the TDCJ told that physician that TDCJ was not going to honor that prescribed course of treatment. Fundamentally, though, Haverkamp does seek proper ex parte Young relief. In determining whether the doctrine of ex parte Young avoids a London Amendment bar to suit, a court need only conduct a straightforward inquiry into whether the complaint alleges an ongoing violation of federal law and seeks relief properly characterized as prospective. That's the Supreme Court's decision in Verizon. Haverkamp has more than met that standard here because she alleges an ongoing equal protection violation and she seeks only forward-looking relief. The state's contrary argument, which it raises for the first time on appeal, is that only prohibitory injunctions are permissible under the ex parte Young doctrine, and that's without merit. To start, Haverkamp does not actually seek the kind of affirmative injunction that the state believes impermissible. To the extent it need be characterized at all, the injunction she seeks is properly characterized as prohibitory. Her treating physician prescribed sex reassignment surgery, and the defendants intervened. Thus, the injunction will prohibit the defendants from continuing to block the prescribed course of treatment, which she was already about a quarter of the way into when the state intervened. In any event, the state is wrong that the ex parte Young doctrine only allows for relief that is limited to so-called prohibitory injunctions. First, it directly contradicts the Supreme Court's repeated teachings in cases like Verizon. Second, the Supreme Court has never held that prospective injunctive relief available under ex parte Young is limited to prohibitory injunctions. To the contrary, the court has long and repeatedly approved affirmative relief in a wide range of contexts, as has this court. Third, the state's argument contravenes ex parte Young's rationale. Fourth, without acknowledging any of the relevant precedent, the state relies on a misunderstanding of dictum contained in a footnote in the Supreme Court case that did not involve ex parte Young at all. Fifth, the state's distinction between prohibitory and affirmative relief has no doctrinal basis, makes no practical sense, and would be impossible to administer because nearly every injunction could be cast in either affirmative or prohibitory terms. The upshot of that is that it would breed endless motions practice to decide whether or not relief is properly characterized as affirmative or prohibitory, where both sides will very effectively be able to argue that it is either prohibitory or, on the other hand, affirmative. Sixth, and finally, accepting the state's theory would work a radical change in the ex parte Young doctrine by preventing courts from ordering state officials to cease violating federal law in a wide swath of cases where the availability of such relief is established. Now, turning to whether or not these are the particular defendants, I think that there's actually little question that Dr. Linthicum, in her role as the Director of Health Services, has both the power and the inclination to exercise that power as relevant here. The state argues in its brief that, in fact, she was probably not involved in the individualized treatment decision regarding Haverkamp, but that's not the relevant inquiry. The relevant inquiry instead, as we do not dispute, is whether or not she has the authority and the ability to and the inclination to exercise that authority. And if what the state is arguing is that as a factual matter, Dr. Linthicum would not exercise her authority to make these kinds of decisions as the Director of Health Services, we would argue that at best, that's a factual argument that should be resolved at a later stage and not at this stage, which again, we have to accept the pleadings, the factual allegations is true. And even with regard to the committee, Haverkamp has sued the correct defendants. She is plausibly alleged in the complaint. Again, we should be looking at the four corners of the complaint here, that Texas prison policy does not authorize sex reassignment surgery as a treatment for gender dysphoria. It's a little disingenuous, we believe, of the defendants to argue that policy G51.11 actually authorizes this kind of relief, considering that when this kind of relief was prescribed by Haverkamp's treating physician, the TDCJ stepped in and said that they would not allow it to be provided. So whether, and a policy, as this court is well aware, can either be written or unwritten. And if the actual boots on the ground decision by decision makers is that the care will not be provided as Haverkamp has alleged in the complaint, it doesn't really matter what the written policy says. And moreover, having affirmatively identified these defendants to the district court as the correct defendants, the state should be judicially stopped from their about face on appeal. It is important here to note that the defendants are correct, that there are two
So
forms.
when these people were identified as a result of this status conference that your opponents have referenced, was there any discussion of waiving sovereign immunity? That just because they named them as potential defendants, on what basis do you say that they've waived sovereign immunity, and what's your support for estoppel?
Your Honor, we don't actually argue that sovereign immunity was waived. We argue, on the contrary, that that even if defendants are able to have sovereign immunity, Ex parte Young applies to them because they are proper defendants under Ex parte Young as a factual matter. What we argue is that their representation to the district court was a fact that these defendants could provide the kind of relief that Haverkamp was seeking. Now, on appeal, they say, no, these defendants cannot actually provide the kind of relief that Haverkamp seeks. And I think it's—
So if I understand you correctly, the very identification of these people gives support to your claim that they are stopped from denying sovereign immunity. Isn't that the argument you're making, or am I mistaken?
Not quite, Your Honor. We are saying that they are stopped from denying that they have the power to grant the kind of relief that Haverkamp seeks. These other arguments that defendants raise about whether or not this is proper Ex parte Young relief, we would not argue that those arguments are waived and that they are properly raised here. We have no qualm with saying that they can raise that argument and that this court has the power to adjudicate that claim. We just simply disagree with the premise that that's what the legal doctrine requires. And it is important, I think, to note that when the district court asked who the proper defendants were for each type of relief that Haverkamp sought, both one for the provision of the gender reassignment surgery and two for a change to the policy, the state presented committee members as to both. Dr. Murray, who the state proffered as the proper defendant for a claim seeking sex reassignment surgery, was a member of the committee. And other members of the committee were also named by the state in their advisory to the court as the defendants who would be proper for a change in the policy. Now, we only argue for the provision of sex reassignment surgery on appeal because, as this court held in Green Valley, all that the plaintiff need is one form of complete relief for the suit to continue. This court need not reach whether it would violate the Ex parte Young doctrine to order committee members to change the policy. It need only find that at the very least, whether or not Haverkamp could be provided gender reassignment surgery is a proper form of prospective relief to seek under the Ex parte Young doctrine. And in any event, even if this court did not believe that some member of the committee is also the correct defendant going forward, whoever replaced Dr. Murray for claims seeking gender reassignment surgery, the members of the committee are tasked with enforcing policy when, as here, there is a dispute between a treating physician and the prison system. We set forth in our complaint how the Texas Government Code Section 501.148A2 provides that, as the defendants admit, they may do so. And we argue that the complaint this pro se complaint sufficiently alleges enough that it's a reasonable inference that the committee did so here. As the Supreme Court said in Lujan 1, at the motion to dismiss stage, the court is to presume the specific facts necessary to support the general allegation. And if the general allegation that Haverkamp made in the complaint was that she was prescribed sex reassignment surgery by her prison doctor, and then that prison doctor, in the course of the higher estrogen, in the course of administering the higher level of estrogen required over a course of 12 months to provide such surgery, was stopped from doing so and told that the prison system would not pay for it, we believe it's a reasonable inference that, as between the doctor and the prison system, the committee was in fact involved in resolving that dispute. But even there, we do not believe that this court needs to keep the committee defendants in the case so long as it also finds that, at the very least, Dr. Linthicum, in her role as the Director of Health Services for the TDCJ, would be a proper ex parte young defendant. Again, if she is not, as a factual matter, the proper ex parte young defendant, the state hasn't said who is, and I would never presume to suggest to your honors what question you should ask, but it would be interesting to know how the state would respond if the state were asked right now who the proper defendant would be that has the power to make the decision that was alleged in the complaint. That decision being to stop the course of treatment that Haverkamp was receiving as prescribed by her prison official. And in any event, on this particular topic, these two appeals, I should say, seem to be a little bit of a tempest in a teacup, because the question that comes to mind is, what else was the district court supposed to do in this case? The district court seemed to do everything right. It dismissed defendants regularly as it became clear due to the allegations that they did not have the power that would make them the proper ex parte young defendant. It has asked a number of times for who the right defendants would be, and it has granted motions brought under Rule 25 for substitution of parties as members of the committee have rotated off and new members have come on. Because this is only an official capacity suit, the suit is against the office itself and runs with the office, not any individual defendant. So at a minimum, even if this court were to believe that Dr. Linthicum, as both a committee member and as the Director of Health Services for the TDCJ, and every member of the committee, were to presume that no member of the committee who has assumed Dr. Murray's role, which the state identified as the correct committee member for the claim related to the provision of sex reassignment surgery, it should grant the relief to dismiss these particular defendants, which is all that the state seeks here. That would be complete relief. And then allow the district court to continue doing what it's been doing all along, and faithfully so, which is to really try to identify who the proper defendant is so that these claims can go forward. I would be remiss if I did not address very briefly how my friends on the other side make a lot of merits noise about why this is not a valid equal protection claim, and how Gibson decided that this is not the kind of claim that can proceed under the 8th Amendment. And on that score, I would say that the defendants have completely abandoned any argument that this court should look at the merits of the case at this stage. And so for the purposes of deciding whether or not this is a proper ex parte young suit, this court should presume that Haverkamp has stated an equal protection claim, that she is being denied care that would be given to similarly situated women. And that is only fair in part because we have not had the opportunity to even brief the merits issue here on appeal, because it has not only been abandoned at this point, but because it isn't even within the scope of this court's jurisdiction. As this court is well aware, the 11th Amendment allows interlocutory appeals Interlocutory appeals are allowed under the collateral doctrine for the denial of 11th Amendment immunity, because 11th Amendment immunity is an immunity from suit. Thus, if defendants were required to get to judgment and a final decision before appealing such an order, there would be no relief that could be had at the end. The same does not go for the merits claim here. And if the state wanted to raise the merits of the 11th Amendment, the equal protection claim that the district court found was plausibly pled, it should have sought Rule 54B certification and certification from this court under 1292B as a controlling decision of law, but it did not. The state did not choose to seek an interlocutory appeal on that question, so this is not the right time to address it. With that, I would just bring to the court's attention a couple of the important cases that we raised in our complaint for why the state is just flat wrong that affirmative adjunctive relief is inappropriate, even in the discretionary sphere in the Ex parte Young context. The first would be Milliken from the Supreme Court, which endorsed injunctive relief affirmatively ordering state defendants to pay 1/2 the additional costs for remedial education programs for continuing equal protection violations. There's the Supreme Court's decision in Kern, which endorsed affirmative injunctive relief ordering state officials to send explanatory notices to plaintiffs to alert them of rights they had been denied in violation of the Equal Protection Clause. Griffin itself made quite clear in its holding that Ex parte Young allows for injunctions that require state defendants to, quote, to exercise the power that is theirs to levy taxes, to raise funds adequate to reopen, operate, and maintain without racial discrimination a public school system, end quote. If that kind of relief is proper under Ex parte Young, should be little question that the limited Ex parte Young relief that Haverkamp seeks on behalf of herself in this case is proper. And even if the state is correct that only affirmative injunctive relief that does not implicate discretionary authority is permitted under the Ex parte Young doctrine, that test too is met here. Again, primarily, we argue that Haverkamp in fact seeks only prohibitory injunctive relief. But even if this court didn't agree, as the Supreme Court said in Owen, there is, quote, no discretion to violate the federal constitution. Its dictates are absolute and imperative. In a case like this, where again, on the merits, we accept that plaintiff has stated an Equal Protection Clause violation, that she has been denied surgery that women in similar situations would be given, the question would be whether or not the state could level down or level up. The state has conceded that it cannot level down in this case because that would violate the rights of cisgender women who would be provided such care. So this case is quite different from a case like Richardson, where there were multiple potential options that a state official could take to remedy a potential violation. I see that my time is up, so if there are no further questions.
Okay, thank you, Mr. Woofter.
Thank you,
Mr. Pettit, you have 4 minutes on the vote.
Thank you, Judge Dennis. The primary response that I hear from my colleague on the other side is that we are raising inappropriate factual arguments. However, as this court recognized in City of Austin at page 943 F3rd at 997, the plaintiff must plead with sufficient specificity and make a plausible claim for each element of their claim, and that includes a waiver of sovereign immunity. And as the district court mentioned, complained, commented, whatever, in that same status conference, Haverkamp has, and I'm quoting here, changed your mind 3 or 4 times in all of these different pleadings, then we have no idea what it is that you want. We agree that the plaintiff should be taken on the 4 corners of the complaint, but that complaint is internally inconsistent. And even a pro se litigant has the obligation to plead a plausible claim, as this court has recognized numerous times, such as in Dunbar against Pena and Payton against the United States. So that is not necessary. That is not a valid response. Nor is he correct to assert that we were identified Dr. Murray as a member of the committee as for the reason why he was an appropriate defendant in that status conference. To the contrary, Dr. Murray was a member of the committee at that time, but he was identified because at that point he was Haverkamp's doctor. And there is no obligation to replace Dr. Murray with another gender dysphoria specialist when he rotated off, and he has not been. He was not named as the defendant for that purpose, and he has not been replaced for that purpose. The next argument that I heard was that there was no requirement under the Larson footnote to have purely prohibitory relief. Fair enough, but in Ex parte Young itself, there said there is no doubt that the court cannot control the discretion of an officer. It can only direct affirmative action where the officer having some duty ministerial in nature has failed to complete that duty. That's page 158 of the Ex parte Young opinion itself. So you can order two things, a prohibitory injunction or an affirmative injunction requiring ministerial action, neither of which is appropriate or pled here. Now, my colleague on the other side said that he's seeking a prohibitory injunction because there was a prescription by the doctor, Dr. Meyer, to provide this surgery. That is also not plausibly alleged in the complaint. To the contrary, there is an allegation that Dr. Murray was, and I quote, very reluctant to allow Haverkamp to go forward and seek sex reassignment surgery. I'm looking at ROA 69. That's in the original complaint, but the amended complaint incorporates large sections of the original complaint by reference, and I think it incorporates that too. Even if it didn't, the grievance procedures that are required by the PLRA specifically state that one of the allegations here is that Haverkamp is in the, quote, twilight zone without a treatment plan that includes this surgery. So the idea that there's been a prescription is simply incorrect. And so the next I hear is that, well, Dr. Linthicum is undoubtedly an appropriate defendant, even if the committee members are not. My colleague on the other side, again, did not mention any allegations in the complaint specific to Dr. Linthicum other than that she is TDCJ's medical director. But as this court has recognized twice in the last month in a case against the Texas Secretary of State, allegations by job description is not enough. And there are no allegations that Dr. Linthicum personally was involved in this case at all. And finally, there was the argument that there's no discretion to violate the Constitution. However, that argument proves too much. Every ex parte Young claim is a claim that the defendant violated the Constitution in any way. And if that was enough to be non-discretionary, Richardson would have come out very differently. It did not. This court is bound by this court's earlier panel decision and cannot order affirmative discretionary relief here. Since that is what was required to give Haverkamp what Haverkamp wants, this case should be dismissed. Thank you.
Thank you, Ms. Pettit. This case and your arguments will be taken under advisement. A ruling will be issued shortly. And yeah. Pardon? Somebody want to speak? The other cases for today, we have dispensed with arguments, and those cases will be taken under advisement also. The panel will adjourn until 1 p.m. tomorrow,